It is.
Yep. So I sent it to Scott this morning.
And he printed it in time before the.
And it should be thinner because I asked for non-competes to be removed from this draft. I've seen more and more federal action on non-competes, and that was the greatest pushback we had received.
Well, so okay.
We're live. Okay.
All right.
Pinch ourselves. I thought I was live the whole time.
Do I have to introduce myself again, Scott?
I think you're okay.
Okay, great. So in section 1, we're amending the Fair Employment Practices Act. The primary change on the first page of the bill is to add the words harass or in front of discriminate. This is really clarifying language because discrimination includes harassment on the basis of a protected class. For reasons of the bill, we're defining harassment to be different than the courts have construed it in the past. It's a broader definition in the proposed language in the bill. And so we've added harass or discriminate throughout so we can then define harassment. On page 2, at the top of the page, you're going to notice a little bit of a change in language in subdivision 4. This isn't a substantive change. Instead, I'm moving the language around and I took out duplicative language that's already covered in subdivision 1 of the section. There's no reason to include the language twice. And then in subdivision 7, this is our, actually perfect timing since it's Equal Pay Day. This is our Equal Pay statute.
Red.
So I did not realize it was Equal Pay Day when I put on a red tie.
You are not good.
So I'm sorry. I put this on before I got reminded of that. So in this, we're adding, currently our law says you shall not discriminate in pay on the basis of sex, and this is adding race, national origin, and disability to that list. It's worth noting that this statute is really belts and suspenders in Vermont. It's a statement of policy, but we're already prohibiting discrimination. And if you're paying people differently based on one of their protected characteristics, that's discrimination. So this language here, though, adds race, national origin, and disability to that list for purposes of sort of setting out the state's position on equal pay. And then what you'll see going on to page 3 is that I continue those changes. I add some of the cross references that our drafting manual now requires.
That's a question. Yeah.
So we're adding these to the protected classes for purposes of equal pay, but we're not adding them to protected classes across statutes.
They're already protected classes.
Right.
And I think you have a very strong argument that For example, if you're discriminated against on the basis of religion, which is another protected class, and you receive lower pay because of your religion, that's discrimination, the same
Yeah. That's
as,
what I thought.
as any other differential treatment.
So we're just calling it out.
Just calling it
equal
out
pay.
for equal pay. Yep. So in the middle of page 3, subdivision 8, you'll see I've struck out the words retaliation prohibited. This isn't a substantive change. It's to make it consistent with middle of page 3, line 12. It's to make it consistent with the style and the rest of the section where we don't have subdivision headings. The remainder of the language prohibiting retaliation is unchanged, so the substance of the law is unchanged. On line 16, this is a substantive addition to the Fair Employment Practices Act. Sorry. This basically says that when you enter into an agreement to settle a claim of employment discrimination, the agreement cannot contain a provision that prohibits the individual from working for the employer or a parent subsidiary division or affiliate of the employer in the future. This is commonly known as a do not darken my door provision. So this has been, I think, last biennium, this committee moved a bill to prohibit these, and it didn't make it across in the House.
Yeah,
So.
it was a day too late for
Yeah, we thought we'd done this. Well, we did do it, it just didn't make it.
Senator Harrison.
Just a question, please. Can this sort of provision be in a separation agreement that's not a result of a claim?
Yeah, so this just prohibits it when you're settling a claim of a violation. So if, for example, this doesn't prohibit non-competes, non-solicitations, separation agreements where you agree that I'm not going to apply to get my job back, but it's not settling a discrimination claim. Maybe there was a disagreement on how the company's run. Maybe it was a claim for non-payment of wages, other things like that. Yeah, anything like that, as long as you're not settling a claim of discrimination. So this is really just focused on, this is really focused on the issue of employment discrimination, and that's it. If the settlement or if the separation agreement is related to anything else and discrimination is not part of it, then this wouldn't apply.
And so the employer can still have a don't darken my door language.
Yeah, it doesn't ban them
Okay.
across the board just for discrimination.
Okay.
Maybe other witnesses will want to address that, or maybe we want to change it.
Yeah. So on the top of page 4, there's another substantive, well, page 4 is all substantive changes. So first is subsection J, and that provides that an employee is not required to demonstrate the existence of a comparable employee for determining whether a violation occurred. So what this is basically saying is you don't have to show that there's a comparable employee who doesn't have your protected characteristic in order to show that discrimination occurred. So the frequent basis for showing discrimination is often, for example, the claimant has a disability and they show that they were treated differently than an employee without a disability. But what this is saying is, if there isn't an employee who doesn't share your characteristics to compare yourself to, you can still bring a claim for discrimination. You just have to prove it a different way. So you would have to prove it based on other facts showing discrimination, not that there was differential treatment. So, and that this is consistent with case law right now. I think you'll hear from advocates on both sides about whether this is desirable language or not. But this language is consistent with case law, but would kind of clarify the position in statute and make it a statutory provision going forward. So it would codify that, which would require courts to apply this going forward. And then probably the biggest change, and this goes back to the addition of the harassment language, is notwithstanding any state or federal judicial precedent to the contrary. So this is a change from existing precedent, and harassment and discrimination need not be severe or pervasive to constitute a violation. And so that right now, the floor or the bar that you have to meet to claim discrimination is you have to show, unless you can show a clear sort of facially discriminatory behavior, for example, an equal pay issue, or quid pro quo sexual harassment. What you have to be able to show is that there was a hostile working environment. And in order to show that, you need to show that either the behavior was so severe that it created that environment, or it was so pervasive that it created that environment. What this would say is you don't need to meet the severe or pervasive bar, provided, and this gets to subdivision 2, provided that a reasonable employee with the same protected characteristic would not consider the behavior you're complaining of to be a petty slight or trivial inconvenience. So this is essentially the difference between someone being rude to you at work and someone taking a discriminatory action towards you. So escalating it to something where there's a racial slur, or someone denigrates you because of your protected characteristic, or probably doesn't make sense for me to just list all the examples, but
Are there
Yeah.
precedents in using this kind of standards? And it would be helpful if there were such precedents to perhaps look at 2 or 3 of those as to how can we came to a conclusion on the basis of this kind of language.
so this, and the advocates can speak to this a little bit more. This is a relatively new provision. New York has adopted this law, but to my knowledge, and I haven't had a chance to do a recent update of their case law, but the last time I checked, they still had not had a case tried under the new language that created a reported decision.
Is New York the only example where this is the case?
So other states are considering it. I know when we considered this language last year, Virginia was in the process of considering the language. I don't know if they passed it. And again, the advocates may have some more knowledge on this about whether other states have actually passed it. This would be a really significant change. There are some, and again, the advocates I think will go into this more. There are some examples of when the severe or pervasive standard has been applied more as a severe and pervasive, or instances where the court has said, yeah, the behavior was clearly discriminatory, but it wasn't quite bad enough to be severe, and it didn't happen quite often enough to be pervasive. So, it really becomes a balancing question on the policy, whether this committee thinks it makes sense from a policy standpoint to change the bar for bringing a claim in court, and I'll let the advocates speak to that.
Senator Clarkson, or do you?
Yeah, no, so I'm just curious, to use all these double negatives on line 10, it's like, why not just say it does constitute harassment instead of not constitute unlawful harassment? Is there a reason to do it all as in that way instead of stating the affirmative what it does do? Or am I just missing the point?
No, I don't think there's a reason to do it that way. I can try to reword it so it's a little bit better. When we drafted this, we based it on the New York statute.
But do you see what I mean? It's like if we're saying creating a statute, we might as well say what is and isn't okay, as opposed to
I
what's.
tripped over the exact same thing when I was reading it. to
Oh, you know what? That
just
makes
now,
me feel
so-
like $1 million thing.
Yeah, so having written this draft, I tripped over the exact same language as I was doing the walkthrough. So if the committee decides to move forward with this, I'll try to wordsmith it so it's a little more clear.
Yeah, I just-
It's
thanks. It's nice to know I'm not being critical of you, but. only of New York
I'm of the
State.
opinion that you shouldn't have to pause and reread a statute in order to figure out.
Yeah,
what it
that's sort of
means.
was, I agree.
So.
I don't have trouble with that. I mean, I read it and I think I understand what it's.
Yeah,
Well, you're a better woman than I.
I missed the and then I was
Yeah.
like, okay, that
Yeah.
was significant.
yeah,
It's, yeah.
yeah, I think you could say, it could be, but, or provided that, you know, and I'll figure out how to wordsmith that. So going to section 2, this gets into the definition sections for the Fair Employment Practices Act. So the first changes on to the definition of sexual harassment. Previously, it said verbal or physical. We've added, the draft adds written, auditory, or visual. And the intent here is really to just try to capture things that were implied to be within physical before, or assumed to be within physical, but weren't clearly within it. So, and that was the effort here, is to provide a little more clarity about the conduct that would fall under sexual harassment. The next change on page 5, little Roman numeral 3, this it formerly C on lines 4 through 6. There are 2 substantive changes here. The first is that instead of saying the conduct has the purpose or effect of substantially interfering with the individual's work performance, we're now saying it has the purpose or effect of interfering with an individual's work. So there's 2 big changes there. 1, it doesn't have to be substantial interference, and 2, you're not looking at performance. So the question is not, was the individual able to successfully maintain their work performance, but was their work interfered with? So, and then the second piece is, previously it would have had to be substantial interference, now it's just interference. So there's really 2 separate policy questions for the committee there on that change. And then in subdivision B, it adds in the need not be severe or pervasive language to track with the previous change. So that would be grouped in with that previous change, depending on where the committee decides to go with that. And then there's a new definition of harass. And so this is really based off of our definition of hostile work environment sexual harassment. So engaging in unwelcome conduct based on a protected characteristic, and the unwelcome conduct interferes with the work or creates a work environment that is intimidating, hostile, or offensive. And then it adds guidance for how a court would determine that. And the guidance here is based off of existing case law. That's not to say that every case followed it, but it took case law, and this is based on what Virginia had proposed. It took case law and then boiled it down into guidance that should be applied, would now have to be applied in every case. So the determination would be made on the basis of the record as a whole, according to the totality of the circumstances, and a single incident could be unlawful harassment. Incidents are considered in the aggregate with varying types of conduct or conduct based on multiple characteristics viewed in totality rather than isolation. So, for example, if an individual is discriminated based on their sex and their national origin, you consider that discrimination, the conduct together, rather than first looking at the instances of sex discrimination and then looking at the instances of national origin discrimination. The next piece is conduct may constitute harassment regardless of whether, and then there's a list of things here. So this isn't saying that, it's just saying that you don't have to have these things in order to have harassment. So the complaining individual does not have to be the individual being harassed. So they can be a bystander who shares the protected characteristic. The complaining employee acquiesced or otherwise submitted to or participated in the conduct. So this is in instances where there may be essentially bullying behavior that the employee goes along with in the moment, and then but feels unhappy about. So they've experienced the discriminatory behavior, they've been harmed by it, but in the moment they went along with the behavior for fear of pushing back or something like that. The conduct is also experienced by others outside the protected class. So this would be instances where, for example, discriminatory materials sort of broadcast throughout the workplace. And so everybody gets the same set of jokes. It wasn't just targeted at the individual. The complaining employee was able to continue carrying out their job duties and responsibilities despite the conduct. So again, this gets back to that interference with work question. So it essentially, the idea is that discrimination shouldn't be determined based on whether you were able to keep doing your job. And then the conduct resulted in physical or psychological injury. So again, you don't have to show that you were physically or psychologically injured in order to show discrimination. And then finally, the conduct occurred outside the workplace. This one causes a lot of folks to pause. The important thing here is that you still have to show a nexus with the workplace. So you still have to show that it affected the workplace. It can't simply be that you saw someone from your workplace doing something outside of work that you consider discriminatory. It has to be that their conduct affected the workplace. So maybe it's an after work function at a restaurant or a bar where racial slurs are used or something like that. So you have to show that there's a nexus with the workplace. And none of this changes the requirements to prove discrimination. What it does do is it sets out guidance for courts and what isn't going to bar a claim. So as I said, this is drawn from existing case law, but these are not applied by every court in every case. So that I think is the important thing. This was guidance and case law that was suggested by advocates last biennium, and they can speak to why they suggested it.
Is this in law anywhere else that you're aware of?
So in statute, to my knowledge, the proposal in Virginia, which I'm not sure if it passed, was the first place where I'd seen this proposed in statute. Some of the advocates may know of other states that have proposed it if that's happened. But this would be brand new in our statutes, having this guidance.
Senator yours.
I just have a question regarding the complaining employee is the individual being harassed, that it doesn't need to be that person. Can a person not in one of these classes allege or show harassment in a workplace just because of being personally offended by it, even though they're not
So
in
in
one of the
order
classes?
to allege discrimination, the first thing is you have to show that you're a member of the protected class. So let's say that there's discrimination based on religion and it's targeting a particular religion. You have to first show that you're a member of that religion. And that's part of the basis for your standing to bring a discrimination.
Okay, so
claim.
bystander.
You can't simply say, I was personally offended by that. But I don't have that protected class. So you can't just be a completely separate bystander without any relation to the discriminatory behavior. You have to share the protected class, even if you're not the individual being harassed. So in other words, if you see a coworker being the target of anti-Semitic comments,
Yes.
and you are also Jewish, you can now feel like you're in a hostile working environment.
But if you're not Jewish, you
You
can't.
wouldn't be able to bring that claim. If there are other comments that target a protected class that you belong to, you might be able to bring a claim with respect to those. So that's one of the main pieces for standing to bring a claim for discrimination.
Are there other options for those, for folks who've witnessed something?
It's really going to get case specific. Generally, employers will have an internal policy for reporting, or I shouldn't say generally, some employers will have a policy for reporting that behavior, regardless of whether you're the individual. For example, here at the State House, individuals who witness something are encouraged to come forward and either talk to one of the panels in the two chambers or to their supervisor, with the idea that as an employer, the General Assembly wants to prevent potentially discriminatory behavior from continuing so that it doesn't become a problem. But that's often your route there. Typically with the statutes here, you have to show that you were directly harmed. And our
Okay,
discrimination statutes don't recognize harm for being a person who finds the joke offensive if you don't have that protected characteristic. In the same way, you might feel that it's wrong that someone's being shorted on their wages, but because you're not the one whose paycheck is being harmed, you can't bring a wage discrimination complaint, although you could file a report of it with the appropriate authorities, and then they could investigate on behalf of the person who's been harmed. But you yourself can't bring that complaint. So, you don't have standing to go to court
Okay.
on your own behalf if you're not the one being directly harmed, if that makes sense. And we don't, in Vermont and across the country, generally it's the individual being discriminated against who has to bring the claim to the Attorney General's office or whoever enforces the
Okay.
employment statutes.
all right, thank you.
Yeah.
That's unfortunate in a way, just because sometimes folks don't want to bring a claim.
Right.
It's too bad that people who directly witness it, but I understand it's a
So-
bigger legal issue, so we don't need to.
Yeah, and that's part of what the regardless of whether the complaining employee is the individual being harassed.
Yeah.
Comes from is that maybe the individual who's the directly experiencing the harassment doesn't want to speak up,
Right.
but someone else who shares the protected characteristic also is experiencing a hostile work environment and can speak up.
Okay,
So,
okay, so there's some progress being made.
yeah, and
But you don't have to be part of the protected class to observe it and witness it on somebody else's behalf.
yeah, you can serve as a witness.
Yeah.
You can speak to HR, you can speak to a supervisor,
You can't bring a claim.
but you don't have the ability to bring a claim in court. You won't have standing
Right.
to go to court.
to
So
be
that,
a claim.
right. So, yeah,
Thank you.
so section 3, this is bringing that definition of harassment to the Fair Housing and Public Accommodations Act.
Is that section 4?
Oh,
Section 3 is the definition.
it's the definition. So 9 VSA 4501.
Oh, okay.
Page
No,
6.
I'm glad to clarify that. I
Yeah.
thought that those were the definitions for the last section. Okay.
Yep. So, yeah, so section 2 was the definitions for fair employment practices.
Oh, there's like similar
Section
ones.
3,
Okay.
they're very similar. So this takes the same language, it applies it to our Fair Housing and Public Accommodations Act, which has a different list of protected classes.
Why? with that?
They were adopted at different times by different legislatures.
So sorry,
So
this applies to what?
race, creed, color, national origin, marital status, sex, sexual orientation, gender identity, and disability.
Right, but this applies to a different,
Fair housing and public accommodations. So, yeah, so this is access to and use of the services or privileges provided by a public accommodation, whether that's the state house, a state prison, or a hotel or a store, something like that. So it's a place that's open to the public. Even if, like a prison, it's only open to certain members of the public. And then the fair housing applies to the sale or rental of housing.
And then that one includes minor children and things that.
Yeah, fair housing adds other protected classes, like having minor children. You can't be evicted because you have children.
Or they can't say we don't rent to, I mean, this is.
We don't rent
been
to
Burlington a
families,
lot.
yes.
Oh, we only rent to students, we don't rent to
Yeah,
people.
or we only rent to young
I've always
professionals
like
without
heard
kids.
that
Yeah, I know, that is,
Yeah.
I feel like it's an
Yep.
underutilized part of the.
But there is the ability to, for example, for someone to limit the number of people that they rent
Yeah.
the property to,
Yes,
which effectively does the same thing.
right. I think in that case, what you're looking at is it a neutrally generally applicable restriction? For example, it's an
Two
efficiency, yeah, or it's a one bedroom, so we won't rent to more than 2 people. So theoretically, a single parent and their single child could rent the
Right.
apartment.
Yeah.
I think where that landlord could run into trouble is if they then said, oh, you've got a child, I meant 2 adults. And that's where, but yeah, there is an ability to say, occupancy is 2 or 3
Two
or
persons,
1.
each of whom
Yeah.
is more than 150 pounds.
Right. So the language in here is tailored to public accommodations and fair housing. So we use the phrase use of a place of public accommodation or the accommodations, advantages, facilities, or privileges that it provides. And then for fair housing, we say terms, conditions, privileges, or protections in the sale or rental of real estate, or in the provision of services or facilities in connection with it. So that includes things like if you live in a condo and because you have children or a disability, you're denied access to certain facilities at the condo. And then, as you mentioned, the intent to occupy the dwelling with 1 or more minor children, recipient of public assistance, and being a victim of abuse, sexual assault, or stalking are added to the list of protected classes for fair housing.
Well, I'm thinking of condos, for example. It's something you frequently see in hotels where it has a pool, is they place limitations on the children being at the pool alone or being at the pool during certain hours.
So that's a good question. I'm not sure how the case law has been applied to something like that versus an outright prohibition.
So I just wonder if
Yeah,
there's additional clarity here.
I think.
I mean, I would imagine it's like a difference between occupying the dwelling and like the privilege of using the pool for certain.
Right, and I think there's also I think you're going to get into some highly fact-specific pieces about questions of, for example, health restrictions and so forth, health and safety, because hotel pools often restrict the hours of use anyway for all occupants or all guests
That's what
because
you
of quiet hours.
Restrictions for children, for example, being in certain areas, if children using the fitness facility, for example, unsupervised.
Yeah, it's
It's quite
the
common.
unsupervised, yeah.
Yeah, and I think it's.
but why wouldn't that, I would assume that was okay.
I would assume it was okay, but I'm just wondering.
That's
if-
based on safety.
Yeah, are we
I think
creating language that might be unduly restrictive, not taking that into account?
So
which
that-
we can fix here before we put it in statute.
This is actually repeating our existing language from the Fair Housing Act and the Public Accommodations Act, just in the definition of harass.
Well, the only question is, does that need to be fixed?
Right, and I think that would be a good thing to hear from folks who represent the condos or the hotels in the state on whether they have issues with that. So, and you may also want to hear from Boryang on how this has been applied, whether the Human Rights Commission has considered those complaints, because she can talk about what the case law on this is in a way that.
That there have been no complaints
Yeah.
until we pass this law, and then of course there will be.
No, I mean, this law is in response to enough things that have triggered people wanting to put this in law.
So-
I assume.
Not children in fitness centers.
Yeah.
And what I'm saying is
Yeah.
the time to fix something is before we put it in statute, not afterwards.
Right,
Right. So
absolutely.
just to be clear, A1 and 2, we are repeating the existing language from the Public Accommodations and Fair Housing Act. In B, we get into the notwithstanding any judicial precedent to the contrary, harassing conduct need not be severe or pervasive. And then the same list of how to determine whether the conduct constitutes unlawful harassment that we just went over in the previous section. So that's the main substantive change is really B. And part of your questions may want to be, how is this going to change the playing field in relation to the existing law? Because that may be your question. And again, I have to defer to the advocates on answering that and where they see the either deficiencies in the current law or the potential pitfalls of adding the language. So, but that's kind of the key change here, really starts from page 9. And it's worth noting that for the Fair Housing Act, we passed this language last year. I've just moved it now to the definition section because we're adding public accommodations. So this language exists for fair housing already. And you'll see later on, I've struck through the language we added.
Right.
We limited it to the fair housing section last year because of concerns about how this would apply to school districts with respect to the student harassment law that we passed a few years back, which provides a clear, severe, or pervasive standard. And because of that, the next thing you'll see going on to page 8 is, or actually page 9, is that the provisions of this definition of harassment shall not apply to any action that's brought pursuant to Title 16, because your remedy for harassment as a student under Title 16, after you've exhausted your remedies under Title 16, is to file a lawsuit under the Public Accommodations Act. The concern last year, and the reason why only the fair housing piece went through and the public accommodations piece was pulled from the bill right before crossover, was that you didn't want to have school districts enforcing one standard and then being sued under a lower threshold for liability. And so this exempts the school districts from that lower threshold for liability when the lawsuits are brought under Title 16. And your colleagues in the Education Committee are considering whether to amend the underlying student harassment statute. So this is drafted just to take that question off the table here, since education is outside of this committee's jurisdiction. So
You struck out entire section 4.
So section 4 is the language we passed last year, which
Yeah.
is now in section 3.
Right, exactly,
With
and
the
incorporated
addition.
it into section 3.
It's incorporated into section 3, which applies to both public accommodations and fair housing. And what we've done is just added back in the public accommodations language with the exemption for lawsuits brought under Title 16's harassment provisions. So, questions? Okay. I know you guys have limited time. So section 4 is the language we passed last year, which is now all repeated in section 3. And then section 5 is the effective date. For those of you who are looking at this in color, the reason it's highlighted is because we had deleted the 2 sections relating to the non-compete agreements. So I just had to renumber. Questions? Okay.
Okay, so clearly we're a little off schedule, but I didn't want to rush Damien so that we all understand the language in the bill. If I think what I'm thinking is each witness now has 5 to 7 minutes. I'm just not sure if Julio is gonna make it. We haven't heard anything from him, but we'll just try to give people 5 to 7 minutes and then, you know, see where we are at the end. That might give people just enough to preview their thoughts or concerns, or people might have more questions for that person if that's the case. This isn't supposed to be like menacing or anything, but it probably just means we're gonna have to add 15, 30 minutes to another morning, because as folks may know, we have paid family leave on our docket this week as well. So we have no more wiggle room. So we'll just give everyone 5 to 7 minutes. And if that means you're previewing your thoughts and we need to add time in this particular morning, we can do that. Damien, you're welcome to sit there while we talk to board. It's up to you.
I'm actually going to run down the hall
okay.
because I was asked to testify on paid leave and health and welfare this morning.
Yeah.
And I don't know if they're going to get to me, so I'm going to check in down there and I'll come
Sounds
back.
good. You're always welcome to hang out.
All right, thank you.
Thanks. Or can you hear us?
Yes. Can you hear me?
Great. Yes, and you might have heard we're giving people 5 to 7 minutes, and people might have more questions for you than that. You might have more to say, so we'll have you back in early morning this week. But we're watching the clock just because of the power outage.
Yeah.
So you have the floor.
Thank you so much. Thank you all for inviting me back. And I have been listening, and I have some answers to those questions that were raised too. But for the record, Borgang, Executive Director of the Vermont Human Rights Commission, and S-103, which is the bill you're looking at today, changes the laws that the Human Rights Commission enforces. And we support this bill and urge you to pass it. And due to the shortness of time, I'm just going to limit my comments today to the severe and pervasive standard. As I mentioned last time, harassment comes from case law, not statute. And it was adopted, widely adopted after this U.S. Supreme Court case involving a woman who had been raped multiple times. And the court finally said, harassment has to be discrimination. And the court said, well, for someone to sue for harassment, it has to be severe or pervasive. The problem is that the U.S. Supreme Court did not determine or did not set out a standard for how bad something had to be severe, and how long something had to occur for it to be pervasive. And so it left courts all across the country trying to grapple with that definition. And the problem that we have now is that we've got courts all around the country, including in the Second Circuit, that have determined that really bad things don't meet that standard. And last time I mentioned a case in the Fifth Circuit where a woman had been touched sexually inappropriately multiple times, and the court said, well, you were still able to do your job, so it's not severe or pervasive. A woman who had been subjected to 16 separate incidents of harassment, the court said that's not frequent enough. It doesn't meet the definition of pervasive. A woman who was in the Fourth Circuit who had her coworkers refer to Hispanic patients as Mexicans, members of M13. These Latino people keep crossing the river, and worse. The court said not severe.
And you
or
just mentioned the
pervasive.
gang reference, right? I just want to make sure everyone caught that.
I did,
Members of M13.
is a gang.
Is it getting?
Yes.
Okay.
Yes, thank you, Senator Vaughn. These are, and there's more and more examples of cases like this, but these are the cases relied upon in interpreting harassment. And judges and lawyers have to follow the precedents that these cases have set. So there is no choice but to find that there is no harassment unless it meets the standard that has already been set by these court cases. The other problem with severe or pervasive is that courts do not understand how to consider the totality of the circumstances when we're analyzing claims brought by a plaintiff who belongs in multiple categories. For example, a woman who is a person of color and has a disability has to independently and separately prove that she suffered harassment that was severe or pervasive on each of those separate bases. So if the same perpetrator was calling her racial slurs, making sexual comments, continuously causing her to fall and trip because of her physical disability, the court looks at each of those separately to see if it meets severe or pervasive, instead of looking at in totality. To answer Senator Brock's question about who else has done this, well, several states have enacted new laws to address this standard. New York eliminated severe or pervasive. Washington eliminated severe or pervasive. The new law says that an act may be considered inappropriate sexual behavior independent of whether the act is severe or pervasive. California and Delaware essentially redefined severe or pervasive. So instead of just saying they're getting rid of it, they redefined it so that it would capture more cases that previously were meritorious but could not find their day in court. And as Damien mentioned, this is not new in Vermont. We passed this law last year in housing. We changed the standard in housing because we said that housing is such an important place that it is important that we look and revisit the way that we think about harassment. And because of that change just last year, the Human Rights Commission found discrimination in a case involving a woman with a disability, with a psychiatric disability, who also was receiving public assistance, who was being harassed by her landlord on each of those bases. Had we not passed this law, we could not have found discrimination because there wasn't enough per her disability in itself, her public assistance in itself, or per her sex. But when we look at it in totality, there were so many instances in which this landlord had subjected his tenant to harassment. And because of that, we were able to find that discrimination had occurred. The ask before you today is to correct a standard that has gone awry. It is to adopt a standard that will capture cases that have lost before they've even made it to the jury. It's important to adopt a new standard because people teach to the law. They teach compliance. And a new law upholds a new standard for behavior in investigations, in teaching and learning about what is appropriate behavior. And it's time that we adopt that standard because it reflects what we expect in a fair and equitable and inclusive society. So I just urge you all to do that. And I'm happy to answer any questions you have. I know there was a question around minor children discrimination that doesn't have anything to do with the severe or pervasive, but I'm happy to answer that if you'd like me to.
That was really succinct. That was 7 minutes. And so we'll if people do have questions, we can have 4 in for another 15, 30 minutes down the road. Flag that for me later.
Yeah, I'm good.
Okay.
Thank
That
you.
was really
That was very helpful.
For a very short period of time. So Carrie, we'll go to you next. The standard has been set, but also just say if you really prefer to have more time another day.
Our standard has been set, but we actually need to reset it. Statute. We need a statutory reset.
All right. Thank you for having me. I'm Carrie Brown. I'm the Executive Director of the Vermont Commission on Women. Damien already pointed out that today's payday. I have buttons if you want to.
I don't have
buttons.
It's discouraging. We're still celebrating 84% in Vermont.
Well, we're better in Vermont. We're better in Vermont. We're more like 91%.
Oh, we're 91 in
Yeah,
Vermont. It's
yeah,
84
so
nationally.
84 nationally. So
84 to the dollar.
yeah, and so I just want to try to make a little bit of that connection for you all. It may be obvious, but the wage gap is a persistent, knotty problem that has a lot of different causes, and one of them really is discrimination, often structural, systemic, unintentional discrimination. So it is rarely a case of an employer saying, I don't think you're worth as much because you're a woman, so I'm going to pay you less. It's much more about systems that are built in place, and the equal pay law that we have, and both Bor and Julio can speak much more expertly to this than I can, is a way of trying to address some of that unintentional discrimination that can happen. And so it's been really important for trying to address the gender wage gap. It also can have some real strength in addressing other kinds of pay disparities that we find. So I'll just talk about a couple of elements of this bill that I think are important to touch on is the part about the no rehire clause, the do not darken my door part. We have this already in Vermont for claims of sexual harassment. We've had that since 2018.
Right.
And so that is really important to understand that this is not a new concept, it's not a new practice. It is simply something that was put in part of a larger bill addressing sexual harassment. There's one element in there. There's no compelling reason why it should not apply to all claims of harassment and discrimination. It's just one of those things that happened in the legislative process, and now here we are. And so this would make it consistent and would recognize that this is actually can be a really burdensome situation for someone to find themselves in, particularly in a small state like Vermont, where if you work for instance, the state of Vermont that employs 8,000 and some people, and you are a victim of harassment and discrimination, and now find that you are unable to work any job for the state government, it is not reasonable. So this is a way to kind of try to address that. Board did a great job of talking about the severe pervasive standard. I will just add that we hear stories like she was recounting all the time. We had somebody call us just recently with a very detailed, very discouraging story about her employment situation with ongoing instances of sexual conversation, asking inappropriate questions, a lot of stuff that, and she had been through the process with her employer and brought complaints, and nothing is changing. And we don't know exactly for sure what's happening, but it seems to be because it's not meeting that severe pervasive standard. And so this change has the potential to make a really significant difference immediately to people's employment situations, as Board described to you in a housing situation it already has. So we're very much in favor of that. And then just the equal pay law part of that, as I talked about before, this can help to address some of the unintentional discrimination or unintentional disparities that can happen. And so it was recently, no, not recently, actually, it was in 2013 that it was strengthened. And 10 years later, it seems like a good idea to look at ways to expand and strengthen it further. And again, I have to leave it to the attorneys to get into more details about how exactly that would work. Happy to take any questions, try to keep it really clear.
Yeah, no, that was beautifully done.
Yeah.
Time for a question. We also, I think when we scheduled this, we went with people's schedules. We didn't know it was going to be equal pay day, but
Yeah,
stick around, we can take a picture.
That was great,
now that
yeah.
we wore our red, or we have our buttons. Yeah, I'm glad we're taking this up today, and thanks for all your work to get us here and remind us why we're doing this. Thank you. Sarah, this is great because we have like exactly 7 minutes for you.
Yes. Thank you very much. For the record, Sarah Robinson. I'm the Deputy Director at the Vermont Network Against Domestic and Sexual Violence. I think this is my first time before this committee this session, so good to be with you all. And I submitted written testimony, so you can read that on the website, but just very briefly, you know, we view sexual harassment and gender-based harassment as part of and an expression of the spectrum of what we would call sexual violence. And we know that this kind of harassment and discrimination causes severe and long-term impacts for the victims that experience it. And we also know that our laws and our current systems responses don't adequately account for people who may experience discrimination based on one or more parts of their identity. And the severe and pervasive standard, which you heard from before, largely originates from case law, has created just an exceptionally high barrier for meritorious claims to be brought forward, and for the totality of someone's experience of harassment and discrimination to be understood and recognized by the court. Board discussed several cases. There are several cases on the federal level, some in kind of housing and employment, others in education, understand that this bill is not looking at education. We do understand that the Senate Education Committee is discussing harassment and discrimination in the education realm. And we do think that those things, these conversations, hopefully at some point will connect. We do think that that is equally important. And there are many examples of people who have experienced very severe harassment or discrimination within educational settings where the standard has also been very problematic. So we very much support changing the severe pervasive standard so that the totality of all harassing behavior and its impact can be adequately addressed. One other thing I wanted to quickly highlight is in section 2, the definition of sexual harassment. So that's subsection B on page 5. And we just think that this change is really important, that does not require that someone's job performance be, that their performance does not need to suffer in order for them to bring forward a claim. And currently, you know, the purpose of or effect of harassment or discrimination has to substantially interfere with their performance. And from our point of view, what you're essentially doing is penalizing someone for doing their job really well, even if they are experiencing harassment and discrimination. So we think that that's an important change. Also support prohibiting the so-called "don't darken my door," and we've submitted written testimony on the pay discrimination as well. So would be happy to answer any questions you have, but thank you very much for your time and for taking this up.
Thank you for your written testimony as well.
Thanks.
That helps when we have it written on our desk. Julia, you have a whole 9 minutes that you came over here for. But again, we can have people back.
Good, and I apologize for coming in with my foul weather shoes and my hat hair, I think.
Oh,
Join the
Hairline drive.
yes. Yeah. Oh, did you drive here just for this?
What's that?
Did you drive here just for this?
Yes, because our power at home is not reliable.
Oh my gosh. Well,
Ours wasn't either.
yeah, it was a very harrowing
Yeah,
drive.
yeah, that's what I hear. Hi, good morning. I'm Julio Thompson. I'm an Assistant Attorney General and Director of the Civil Rights Unit. I know we have limited time today, so I thought I would hit on a couple of areas where I've seen in prior testimony, it seems to have caught some of the curiosity of the committee members. And I'd like to start with equal pay provisions that were in discussion, I think, in the introductory session there. The background there is in 2013, our office with the EEOC and the U.S. Department of Labor hosted a conference at University of Vermont on equal pay to look at different ways to try to close the pay gap in Vermont, which has been persistently wide since the 60s, some narrowing in the early 80s, but then kind of stuck. As a result of that conference, there was proposed legislation here in Vermont that did a number of things, including clarifying some of Vermont's equal pay laws, because different courts have different interpretations about how broadly that law sweeps. The Vermont law is based on a 1963 federal law. And also to introduce the concept, which seems quaint now, that employees could ask for flexible work arrangements without losing their jobs. Now, COVID sort of makes that kind of mainstream now, but it wasn't mainstream in 2013. So I was very involved in this committee back in 2013 to talk about the equal pay bill. One thing I really wanted to just zero in on that for today there are two things. One, the extension in this bill would be to cover equal pay not only for sex, where it's been since the 60s, but for race and national origin. Our office supports that. We do see a lot of empirical data that particularly women of color, but also men of color do a lot worse than their white counterparts. We're a little bit more concerned about disability for a reason that's not obvious at first, even though there can be pay disparities for folks with disabilities. The mischief, we think, in that language that needs to be explored a little bit more is that not all disabilities are known to the employer. And because in order to have an equal pay violation, you don't have to show an intent to discriminate. It's just the fact that there is this disparity. Employers with an incentive to comply with the law would have an incentive to discover all the disabilities in the workplace. For us, we're concerned it creates a permission structure for the employer to send around a poll and say, please tell us all who you're disabled so that we don't discriminate against you. Under federal law, under the ADA, it's a per se violation of the law to ask a person a disability-related question unless you can show a legitimate business reason. In Vermont, under existing law, that kind of poll would not be permissible. And our concern is that if you add disability to this law, you've created a business justification for employers to make that kind of inquiry. So we think that that area, there needs to be some additional layer of protection or something, because it's very worrisome for us, the idea of employers to, under color of a new law, to say we're doing an equal pay audit, which and equal pay audits are great to do. But to say, yeah, but in order to do that, we need to know the full class of health conditions in our office to make sure that we're not inadvertently discriminating against you. Even if the employer is doing that in good faith, it's hard to unring the bell. That's why Vermont and that's why federal law has, going on 30 years, really seriously protected health information. So that's a concern of ours. I'm not saying it's an insoluble problem, but we think that is a problem that needs consideration. We don't think race or national origin, even though there are always cases on the margins, we don't think that presents nearly the same kind of difficulty. The other aspect I want to add on, in the bill, and this comes just in a particular language, and I think it's just a drafting issue. It has to do with page 4. It's subsection J. I'm sorry, I'm talking fast. It's a lot of ground. In subsection J, it says that employees should not be required to demonstrate the existence of another employee to whom you can compare them to in order to find a violation of FIPA. And I think that works in many types of discrimination cases. For example, it could be race discrimination or occupational segregation, where someone's assigned menial jobs even though they have qualifications. There may only be one position. So the fact that you can't show, for in a race case, for example, that an employee of a different race had better conditions, that makes total sense. And in fact, a lot of the case law says that anyway. Where this clause doesn't make sense is in the equal pay context, because by definition, equal pay claimant has to show that there's someone of an opposite sex who's getting paid more. So I'm not even sure how I would interpret this paragraph in light of the equal pay law. It just seems to me that it needs to be somehow cabined off so that this paragraph does not apply to equal pay claims.
So right now, it's not in the equal pay section. It's in the,
But it applies,
okay,
it's in the same section as equal pay.
okay.
So it would apply to the equal pay as well as the other forms of discrimination.
Okay, then I understand that and.
Yeah, I think that's just
you
a
need to
minor
have
fix.
comparable
Yeah.
Thing, okay.
It doesn't even have to be
Yeah.
a current employee, it can be a former. So if you hire a woman into a job and her male predecessor got paid more for doing the same work, you still may have an equal pay claim. But if you say, if the other person was a female predecessor and you don't have to show it, I'm not sure how you demonstrate equal pay, a violation. So I think that's just a minor area. The other area I want to talk about, I'm sorry, go ahead.
No, I'm just curious. I mean, is there a way to clarify that so that we?
Yeah, I
all
think you
of
would
the-
just exclude.
I was
that
hoping you
subsection
could
on
propose
equal pay.
language with state
Sure.
by
Yeah.
by Thursday, Friday would be great.
Yeah,
I think
sure.
Thursday we have it up for a possible vote. So.
Okay.
Okay,
I think it's fixable just by Scrivener's work,
so,
drafting work.
so just so while we're on the Scrivener's work,
Mhm.
is
Friday.
it possible for us to also clarify the disability piece? I mean, because that's a little thornier. I mean, that's sort of, that's sort of a key pillar of this work here, is adding
Comment?
disability.
I think at a minimum, you would, just shooting from the hip, I think something that just expressly says that nothing in this section authorizes an employer to make an inquiry about disability. So that you would be basically trying to cover known disabilities, because there'll be some employees in a wheelchair, for example, or who
Well,
use
that are
assistive-
apparent,
Yeah, that are apparent
But-
or already disclosed.
but there are many disabilities that can affect life that obviously aren't.
I don't have current numbers on it, but it's been widely recognized that most disabilities are not visible. High
Yeah.
blood pressure, infertility, any number of psychological illnesses or impairments.
How can an employer defend against discrimination on a disability that they didn't know about and was not apparent?
I think if you circumscribe the language, the unknown disability, I think you would probably have to demonstrate that the employer was aware of the disability in order for that to apply. Because the foundational basis for like sex discrimination back in the 60s, remember the federal law was passed, thick in the Mad Men days. everybody knew what a lady worker looked like then, because frankly, in a lot of offices, it was so rare. But we're dealing with a much broader set of laws these days, so it's a fair point. The other point I wanted to raise, and I'm probably running out of time, had to do with the business justifications that are a defense to equal pay claims. So the existing law, and actually I uploaded the document. My computer's not working right now, so I can't put it in front of you. But one of the defenses to an equal pay claim is, you can defend a disparity in pay for merit, seniority, education, and then a bona fide business reason that doesn't perpetuate a sex-based discrimination. So like if you hire from an employer that has been discriminating against women, that's the typical example. You can't just rely upon that. But the examples that we're given, like what if there's a COVID-related labor shortage, for example, there's an exigency in the market, and if I have to lure in, maybe that's the wrong word, I have to attract an employee with a higher wage. Does that mean I have to raise everybody else's wages? The answer plainly is no, you do not. If that is the reason and the cause of the wage disparity is a market exigency, that's in the law. And in 2015, the Vermont Supreme Court interpreted that law in a case involving a correctional officer or a food supervisor in the Department of Corrections who was hired at a higher wage than a female counterpart who was already there. And one of the justifications that was offered and accepted by the trial court and affirmed by the Supreme Court was that there was a tight deadline for opening up a new facility where they had 350 inmates and 150 staff to train. The court said, interpreting that provision, that's a market exigency that's untainted by a history of sex discrimination. It's just simply that people are shorthanded. So now there can be cases about like what are the market exigencies and so forth. But my impression is that the existing law came off to be a little bit more onerous on businesses than I think it actually is. We've had cases where we have disparities, and it's really that kind of thing. We had a case, I can't name the trades involved, but one where they were very shorthanded and they had a big shipment of business coming in, and if they didn't have people to staff it, they were going to lose the contract. And that was a case where the incumbent employees were obviously very upset. We looked at it, we were satisfied that it was that time constraint that really, it affected the negotiations by the employee. He knew he had the employer in a weaker position. And so we didn't find a violation. We didn't proceed with the case. I'm going to check for time because I may be out.
Yeah, it's 12:01.
Okay.
Do people want to hear sexual harassment now so we don't have to? Yeah,
I could clear a lot of ground. I
Okay.
can't tackle severe and pervasive, but there's a lot of other stuff in here. I think I could clear the ground to answer some of the questions that Senator Brock had this morning, for example.
So what I'm thinking is, because you had some suggested language changes as well. Right now, basically, we have 3 bills up for a vote for 2.5 hours on Friday. So as long as I feel like we are like just answering legislative questions at that time, we can ask you to come back before we vote, or people can talk to you outside of committee if they have significant issues before Friday. What is the committee?
Well, I have another meeting that's gonna be by 10 after,
So would you rather have Julio come back in? Okay,
because otherwise we're gonna be rushing through this.
sure.
Yeah.
So why don't can we aim for Friday, adding a half an hour,
Okay.
and then we'll put that up first.
At what time, meeting early on Friday?
Yeah,
I have
8:30.
an 8 to 9 meeting on Friday.
Oh, okay, which day? So Wednesday or Thursday?
Thursday I could do it in the morning.
Okay, so Julio, are you available at 8:30 on
which day?
Thursday morning?
Sure, I'll make myself available.
Okay.
I don't have my calendar with it, but I'm sure I can make it happen.
Okay, so we'll add you for half an hour at 8:30 on Thursday morning.
I will need a half an hour, but so if other people, if you want to hear from.
Let's add that half hour
Yeah.
just to keep it, and then you're right, maybe we will have to. add
You should never go
more, too.
lawyer. so-
You can sell your minutes.
Yeah, it sounded like, Gore might have more to say. that
Yeah,
kind of thing.
yeah.
So, we'll take this bill up for another half hour at 8:30 on Thursday. Thanks so much.
All right, thank you.
Thank you. Thanks, everybody, for dealing with the power outage. So there was something I was gonna say. just
Probably many things.
I guess note our schedule, we have some things where we have witnesses and discussion. Scott's done a great job since we all got back from our various
Adventures.
adventures. So I would just look at this, and if you don't feel like there's a witness you need to vote on a bill, let me and Scott know so we could, and Allison, and we can schedule that.
So what are we doing about our firefighters from today?
So actually, that's another thing. If people have the new draft on your desk, it has the one change that allows for cancer screening to occur after the person becomes a firefighter, and it has a big study. And we're having Mike DeRocher come in. So I feel like Damien is on hand for us all week for like an hour a day. So if you have big problems with that or see concerns, it's pretty straightforward, and it wasn't going to take a half an hour, but now we're also our little half hour wiggle room spaces. So with the
we had a half an hour wiggle room yesterday, and it evaporated.
yesterday.
No, when we talked.
Oh right,
Like,
yes.
what if they
Yeah,
do it
no,
11:30
there was-
wiggle room?
So I guess if people can just look a little bit ahead and look at the schedule.
I'm gonna go to childcare.
That's right. We all
I
have
have
to
to
pay
pay
for it to do.
12:30
So-
caucus, yes.
I
good
did
luck
not make
figuring-
that one. I'm gonna get lunch, so.
Well, come join us and come
And
meet
we're-
us.
I will bring my
We're
lunch.
ready to, is